I'm Rishi Bhatt, and I'm an attorney at MNK Law. MNK Law is a boutique firm based here in Los Angeles County that is committed to empowering businesses to become the best version of themselves. All good and bad things, as the case may be, in life must come to an end. The same is true in the employee-employer context. It is important that employers take a cautious, measured approach when handling an employee's separation. Employers must not act precipitously, but must act wisely and in compliance with all applicable laws. Typically, an employee-employer relationship ends in one of two ways: through a termination or through a resignation. A termination occurs whenever an employer ends an employment relationship, perhaps for behavioral, conduct, performance, or economic reasons. Now, terminations for behavioral, conduct, or performance reasons are colloquially known as firings, a phrase that you may have heard often. Terminations that occur for economic reasons are known as layoffs, or more fancily, reductions in force, aka RIFs. As you can imagine, termination is not an easy moment for any of the parties involved, neither for the employer nor for the employee. Regardless if the termination is warranted, an employee will feel the impact of the termination. Likewise, the manager conducting the release will experience some discomfort or displeasure. While being situated in a termination context is not an ideal situation most people dream of, terminations are a reality of the employer-employee relationship. So it's imperative that an employer do the following as part of its risk mitigation strategy when dealing with terminations. First, you must ensure that your employees have their final paycheck on the very day that you terminate them. In California, employers must issue final payment to an employee on the very last day that the employee is terminated. No delay is allowed. There are no exceptions to this rule under the law. The penalties for failing to do so, unfortunately, are draconian. They consist of up to 30 days of unpaid wages, a sum easily leading up to thousands of dollars of extra penalties for employers. Not only that, but delayed final payouts are a gigantic source of lawsuits against employers. Second, it's imperative that an employer collect and review all of the documents relating to the terminated employee, especially all of the documents supporting your decision to terminate that employee. For instance, if an employee is terminated because of behavioral reasons, collect all of the relevant policies, communications, and evidence of the employee's violation of the code of conduct, and review the same. In our experience, employers too often fail to do this as they are eager to let an employee go. But this step is critical to show that an employee is terminated for some legal reason and not some illegal purpose. And it's critical to inform the employee or its counsel, its lawyer, if it should engage in additional documentation before terminating an employee. Third, communicate the termination decision concisely, clearly, and privately. Termination, as you can imagine, can be very embarrassing for an employee, and an embarrassed employee is an unhappy employee, and thus a source of potential litigation. You want to inform the employee of the termination decision in private and away from any office traffic, and communicate the decision concisely and clearly. Fourth, it is imperative that an employer give the terminated employee any required notices and any reminders of their continuing obligations to the company after they leave. Terminated employees are entitled to certain notices under the law, including information relating to their continuation of healthcare benefits, unemployment benefits, and additional notices such as a change of relationship form or the DHCS notice to terminating employees. A list of additional documents may be found in the description box below. In addition to providing employees a list of required information, you want to remind the terminated employee of their continuing obligations to your company even after they leave. These obligations may include, without limitation, duties of confidentiality or of data destruction. To summarize, separations at work, as in life more generally, can be messy and fraught with peril. But when done correctly, employee offboarding can help minimize legal liability and help defend an employer from baseless claims. Employers like yourself need a business advisor who is also a knowledgeable attorney. Staying out of lawsuits is one way to build and prepare for your future. They are interrelated. If we can help, please visit us at mnklawyers.com or email us at info@mnklawyers.com. We'd be happy to help.